Good afternoon, everyone. We are back for the last panel of our conference, last panel for today, and also last panel for our 2 days conference. We have 3 presentations in this panel with some rearrangement that we had during the day. So we are going to have as first our co-chair for this conference, Professor Matjaž Nahtigal, and also our host here at University of Ljubljana, Faculty of Social Science, that will be presenting just energy transition, SDGs implementation, and the constraining development space. So I give immediately the floor to Matjaž, and thank you, Professor Nahtigal, to be here presenting as well. Thank you very much.
So thank you, Professor Paolo Farah. Good afternoon, everyone. Thanks for still being with us. So the title of my topic relates to the issues of the shrinking policy space and what to do about it, what can be done. So in addition to this already identified and recognized developmental issue or problems in relation to the Sustainable Development Goals, as well as to the just energy transition, there is a huge funding gap, as we know, as it has also been mentioned several times also in our during our conference. So the identified funding gap to implement Sustainable Development Goals, for example, is already to the tune of like $1 trillion, for example, in order to implement the proclaimed sustainable goals. Now we know that we are far off track in many aspects of the Sustainable Development Goals in many parts of the world. And in some aspects, developments are going in the opposite directions from the desired one and declared one in 2015. In addition to this, there is a huge need for funding energy transition all over the world. And there is also a growing gap between the actual implementation of these needs and the actual activities. So there is this huge funding gap, and there seems to be very little current commitment to change it, to improve it. So just to give you one example, with the increase of interest rates in by the main central banks in the world in 2021, 2022, this has hugely increased the burden on public debt of the many developing, if not all of the developing countries around the world. And only the increase of interest rates in 2022 represents the overall amount necessary for the developing countries to implement the Paris climate commitments. So just to give you an example how the global funding, the global financial architecture, monetary architecture, fiscal arrangements, financial flows actually create these huge, let's say, disparities. Measures, legitimate, necessary in some parts of the world, affect many other parts of the world without contributing to the situations, economic, social conditions in other parts of the world, but they are hugely affected. So this means even if these already existing instruments that are in place and not sufficiently fulfilled, such as official development aid, such as development aid, other forms of development aid, bilateral, multilateral, they are completely inadequate. And the funding is actually here. Just to give you another example, last year in 2022, the European countries had to spend to the tune of 800 billion euros in order to prop up energy prices in Europe, to contain the energy crisis, further energy crisis for households and industries. So the additional subsidies in Europe to all other spendings were spent. The overall assessment is that it was spent 800 additional billion euros by the European governments only in 2022. So this gives us some perspective of the missing funding in many parts of the world, and also it gives us a perspective that actual resources they exist. They are not just, but they are not properly allocated. So these financial flows, monetary activities, financial transactions, they create huge financial volatilities that are suboptimally allocated all over the world. So this is only this macroeconomic global aspect of, let's say, monetary inconsistencies, incoherence of current policies that actually trump many of the efforts, many of the developing countries in order to pursue more sustainable, more inclusive developments. So no matter how hard they try, they can be easily preempted by other much stronger financial forces, developments in other aspects. But even all this having been said, this is not even my main issue or my main research question. I'm just saying that this requires a rethinking of the international monetary framework, financial framework, of search for stronger tax base all over the world, capacity to raise revenues when necessary, capacity to invest where necessary, to coordinate these activities by all the governments, developed and developing alike. But even if this would, hypothetically speaking, would have been improved, I think this would still be inadequate. Why? Because the history of developmental efforts suggests that in the aftermath of the World War II, for example, the Bretton Woods institutions, the mechanisms of development, official development aid, of many other forms of development aid were inadequate. They did not, in relative terms and absolute terms, did not contribute to a more sustainable, more balanced international developments all over the world. So something must be missing. And my claim is, or my research question to myself, and you may or may not agree with this, that we need to enhance policy space. We have to return policy space, but I will explain what do I mean by policy space. I mean by policy space capabilities, instruments and tools that are necessary for articulating and implementing developmental policies bottom up by the local governments, local communities, regions, national governments, and then at the top of international organizations, international institutions. So, in the current model of development that is in place for the last 4 decades, there was a strong concentration of finance, of knowledge, of technologies, of finance in the hands of very limited, privileged sectors of economy, privileged areas, regions of economy in developed and developing parts of the world. And there is a huge gap with the rest of the economy and the rest of the society. So this created some kind of a global, concentrated economic and social hierarchies in the hands, so they created these privileged segments in the hands of few, advanced economies, advanced regions, advanced multinational companies, shareholders, and excluded all other parts of economy, society, regions, stagnating, local communities, and so forth. So if there is one book that I would really like to recommend to read over the summer, if you have not yet done so, is to read a book by Matthew Klein and Michael Pettis, Trade Wars Are Class Wars. And the subtitle of this book is How the Rising Inequalities Are Contributing to the International Conflicts. It was written in 2020. It was widely acclaimed, widely discussed. So I think this is a very good starting point also to my problem. Because they're saying that, like open trade, investments, financial flows, they definitely contributed to the overall development, prosperity, but in highly unequal ways. So they created also huge inequalities. Maybe not so much at the global levels, because by some estimates, the global inequalities are decreasing, but especially inside the countries. So they have huge, strong distributional impacts within the countries. to create, let's say, those who are relatively privileged, who benefit from this arrangement, and many other segments of economy, society that lose out, that they don't have access to the benefits, to the opportunities that the current form of globalization is creating. So my claim is actually that we have to reclaim and reinvent the policy space. And how to do it? How to do it basically is to return instruments, tools, initiatives to the at a decentralized level to reinvent policy space. And this was maybe few years ago, it was a very academic, abstract discussion. But now we see that even the most advanced part of the world, the most developed countries in the world, they started to reinvent industrial policy. Industrial policy was in its own traditional style. It was completely almost abandoned and almost forgotten or pushed aside as an obsolete instrument, as an obsolete tool, with the advancement of the WTO, with at the height of international trade liberalization. Now the recognition has come, almost overnight, that even the developed countries, they need to launch their own or to pursue industrial policy. But this has come, I would say, in kind of a context that did not sufficiently reflect the developments, the past developments, the deficiencies, inadequacies, and what are the challenges. So now this industrial policy can be also a problematic. In which sense, if it is not properly devised and implemented, it can actually maintain the chasm, the gap between the continuously privileged advanced sectors of economy regions with even additional subsidies and support at the expense of everybody else. So we would also have to reinvent industrial policy for the new context. So we would have to also develop new instruments, new institutions that would overcome the previously described gaps between the advanced sectors of economy and the large parts of the stagnating economies, large parts of stagnating regions. And it seems that for now, nobody really knows how to do it, how to establish model of inclusive, widely shared development for the many. So the risk is now that with these huge amounts of money being spent in the United States, in Europe, with this newly created race of subsidization, we will just, instead of improving overall prosperity, we can only replicate or reproduce inequalities, inequities within the societies. In developed, and if pursued in a similar way, also in developing countries. So we will end up with this green transition, energy transition, even with more social inequalities, with wider gaps between different segments of society, between different segments of economy, regions, and so forth. So, so the potential answer to this could be to reinvent the policy space, right? According to the idea of special and differential treatment with the WTO, with the common but differential models of Paris Agreement approaches. But for this purpose, we have to also move beyond existing institutions. We have to we have to produce more institutional innovations. And we have to develop new instruments and new tools. With the previously existing tools, instruments and institutions will not be able to share, to disseminate knowledge, technologies, finance, know-how, good practices to the rest of the economy and to the rest of the society. So therefore, we need to reinvent policy space in a more institutionally creative and structurally creative ways. But as I said, nobody really knows how to do it. There are a few exceptions. There are a few sources of inspiration and encouragement in all parts of the world, developing and developed, but they present only exceptions to the general rule of traditional standard model of market economy, civil society, representative democracy. So we would have to, right? We would have to start producing new institutions that would support more inclusive development. What would these institutions look like? For example, just one of many possible institutional innovations that I would like to put on the table for our future thinking, for future imagination. There can be, for example, regional public venture funds. Venture funds that would provide equity. Equity to whom? Not to large businesses, not to multinational companies that are already competitive. They're so profitable. They have so many of their own resources at their disposal. They don't need additional public support. We would need to support startups, small and medium-sized firms that are excluded, to provide long-term equity to them. Not only in forms of patient capital, but also in forms of access to technologies, new technologies, advanced technologies, better managerial practices, so that we can equip young entrepreneurs in the, let's say, stagnating regions, local communities. So we can create new support centers, training centers for all these people who cannot participate, who cannot follow rapid developments in intensive knowledge economy and knowledge society. And these forms of innovations, this form of redirection of a newly reinvented policy space is something different from the traditional industrial policy. It's actually not primarily even about subsidies. It is primarily about dissemination. So public sector, public institutions, regional, for example, developmental agencies, they should be able to understand the new technologies. They should be able to enter like good firms, advanced technologically advanced competitive firms, learn from them, learn technology, production, new practices, marketing, and disseminate, to share with other firms that are still learning, that are trying to improve. So we would create an environment of dissemination, support, experimentalism, participation, exchange, like clubs. We have some advanced developmental regions in developing countries of the world, but these are only exceptions to the general rules. So we would have to expand, right? We would have to disseminate more of this experimentalist institutional support for new economic activities in a form that can be described as a decentralized strategic public-private partnership between public sectors and between the entrepreneurial, creative forces of private markets. So in order to do this, we can discuss whether the current framework is too constraining. Even some trade experts say that there are so many provisions that you also identified already at the disposal, but only if the governments knew how to do it, how to use these opportunities. So it is, I would say, many of the rules that you also are specific rules they present a constraining factor. TRIPS rules, many of them, and implementation of these rules. Sometimes rules in the areas of subsidies and countervailing measures, the code, which is very constraining. It has become much more constraining than the previous GATT regime. And we have to make a distinction between potentially beneficial subsidies, potentially harmful subsidies, and probably outright harmful subsidies, like subsidies for fossil fuels that are still exceedingly high. And they are definitely harmful. So we see this. So we have to rebalance first the definitions, the concept of what is a modern industrial policy, what is how to redefine the potentially acceptable subsidies vis-a-vis potentially harmful subsidies in a more relaxed manner, as it was in the past of the GATT regime, in order to open space for modern industrial policy, not to subsidize, because now it's a hype to subsidize, but in order to launch new, more innovative, more productive ways of industrial policy, of developmental policy, that is always an outcome of collective deliberate process and participation and cooperation between public and private sectors in decentralized, participatory, experimental manner and transparent manner. So this would have a potential, right? This new modes of policy making of institutions can become a pillar of a more inclusive, sustainable ways, and only in this context it would make sense first to foresee green economy transition, also socially more inclusive transition. Otherwise, we may risk even more resources that would simply replicate global, national, and regional inequalities. And they would simply entrench social divisions. So this is I would say, the test, the task of all of us at the international levels of polity and all other levels of polity, national, regional, in developed and developing countries, parts of the world. And this would also overcome this now stifled conflict between, let's say, global North and global South, because there are also huge social divisions in the global North countries, with a lot of stagnating regions, with a lot of excluded population that is actually losing out, that does not have even traditional access to high quality public services, high quality education, better opportunities. So this is why the global North countries and governments are so reluctant to commit more, even to the existing commitments like ODA and others. So in order to redirect international developments, we would have to find a new global development consensus. But this would not be a one-size-fits-all top-down approach toward development, as the case with the traditional IMF, World Bank, WTO approach, technocratic approach. We would have to have a more diverse development, decentralized, pluralistic coexistence of different models. And this is how to overcome, right? So this is why we need more institutional creativity, imagination, ideas, initiatives that should come from somewhere. If not from legal experts, from economic experts, social experts, from the civil society, from whom? They will not come from global technocrats. They will not come from global multinational companies, because they are in favor of status quo. So they have to come from somewhere to build new alliances, to create new opportunities, to create a new win-win situation, like creating a new Bretton Woods system for the 21st century. This is our task, it's our hope, it's our goal. Thank you very much.
Can do it. There are questions, burning questions. Okay, now we are going to have the second panelist for this last panel of the conference, Martin Žvek from Masaryk University in Czech Republic, and he will be presenting on persistent imbalances in EU effort to ensure secure and sustainable supply of critical raw materials for European industry. So we will have him and the third speaker, and then all the questions will be at the end for all the three speakers. Thank you very much, Martin, to be here with us.
Thank you very much, Paolo. Ladies and gentlemen, distinguished colleagues, good afternoon. I would like to say that it's a great pleasure for me to be here in Ljubljana and to be part of this wonderful conference addressing very important issues and questions. My presentation is going. Now it's presentation. Yeah, this is my presentation. Persistent imbalances in the EU's effort to ensure secure and sustainable supply of critical raw materials for Europe's industry. And let me begin with the first statement. The role of critical materials in clean energy transition is going to be absolutely crucial. And to provide you with some evidence, let me quote one of the latest findings of International Energy Agency. Now I quote, "An energy system powered by clean energy technologies differs profoundly from one fueled by traditional hydrocarbon sources. Critical minerals such as copper, lithium, nickel, cobalt, and rare earth elements are essential components in many of today's rapidly growing clean energy technologies, from wind turbines and electricity networks to electric vehicles. Demand for these minerals will grow quickly as clean energy transitions gather pace." And the European Union often presents energy transition as a way how to escape its energy dependency. However, it's very likely that the European Union, if not substantial change in its approach towards security of supply of something, in this case of raw materials and critical materials, the European Union is just going to shift from one dependence to another dependence. However, let me be positive at this moment. The European Union is aware of these risks, in contrast with talks a few decades ago when we could have prevented our massive dependence on energies, on energy supplies from third countries. Europe is just willing to take necessary steps to prevent being as dependent as we are on fossil fuels from third countries. In this context, I would like to provide you with this chart. It has been produced by the OECD, and now once again I will quote, "While the production of trade of most critical raw materials has expanded rapidly over the last 10 years, growth is not keeping pace with projected demand for metals and minerals needed to transform the global economy from one dominated by fossil fuels to one led by renewable energy technologies." So it's very much clear that the future energy system of the European Union is going to need a huge amount of all these minerals and raw materials. And to make it even more complicated for the European Union, a lot of these critical materials are to be found in only few countries around the world. Sometimes fewer countries than oil or natural gas. You can see top 3 producers of top 10 most production concentrated critical raw materials. I think it's maybe too small, but if the presentation is afterwards provided, you can read it, or you can find the report made by the OECD called Raw Materials Critical for the Green Transition, Production, International Trade and Export Restrictions. You can find them by yourself and look at this quite interesting and quite worrying from the European perspective chart of 3 producers of top 10 production concentrated critical raw materials. Why is this issue relevant for the purpose of this conference? You will find out that most of these countries are developing countries. It brings me to, now I would like to start with the first moment when the European Union realized this problem. It was in 2008 when the European Commission issued its raw materials initiative. And you can see that the EU puts very clearly that While the rising cost of energy and the high dependence of the EU on energy imports is already high on the political agenda, comparable challenges regarding certain non-energy raw materials have not yet received full attention. This is in 2008. Luckily, in 2023, the European Union is well aware of this problem, and a lot of measures have been negotiated, and already some proposals have been issued by the European Commission. Let's see when all these proposals are going to be translated into law, into European directives and regulations. What I do find quite interesting that already in 2008, the European Union is aware of two different aspects of its dependency or potential two different aspects of European response to its dependency on non-energy raw materials. The European Commission stated, on the one hand, the EU has many raw material deposits, which is very much positive observation. However, their exploration and extraction are facing increased competition for different land uses, and especially a highly regulated environment, as well as technological limitations in access to mineral deposits. So I would underline the highly regulated environment. The European Union in 2008 admitted that although there are raw materials located within the European territory, its environmental standards are so stringent that European companies do not extract or are not even considering being engaged in extraction of these materials. The second side, or the second aspect, on the other hand, Europe is highly dependent on imports of strategically important raw materials. So we are going to distinguish between raw materials or critical raw materials located within the European territory and those located beyond the European Union. And this conclusion or this paragraph of 2008 Raw Materials Initiative reminded me a lot the European approach towards classic energy resources. And let me use coal as a very nice example of European naivety or very naive approach towards its energy security, in contrast with its sometimes unrealistic or super ambitious approach towards climate change and CO2 productions. Once again, let me remind you what the European Commission stated. Companies engaged in exploration and extraction of raw materials are facing increased competition for different land uses and highly regulated environment, as well as technological limitations in access to mineral deposits. When it comes to coal, the European Union is very much ambitious when it comes to decreased production of hard coal within the European Union. And there are very good reasons for that. It's dirty, it causes CO2 emissions. And last but not least, the European Union would like to show a future direction or to present itself as someone, an actor being very much concerned about the CO2 emission and then climate change. So therefore, you can see that in the European Union, in 2021, production of hard coal was 57 million tons, almost 80% less than in 1990. So one would say it's very remarkable. The European Union is doing very well when it comes to production of hard coal. However, in 2020, 39% of inland consumption of hard coal in Europe could be covered by production in the EU compared to 71% in 1990. It means that the European Union solved the problem by outsourcing production in hard coal and moving the production beyond the European Union. So the European Union reduced its consumption of hard coal. However, much of the hard coal now being consumed in the European Union is produced beyond the European Union. So from the climate change perspective, it's very remarkable. European Union can use these data regarding production of hard coal. However, if you add data regarding European consumption in hard coal, the picture is more complete and more realistic and telling what's going on in the European Union. It is very concerned. It is very worrying consequence, this strategy or this approach, because you are increasing intentionally your energy dependency when you are relying increasingly more and more on imports from third countries. So this is exactly what happened. The European Union wanted to present itself as climate concern, or as ambitious when it comes to climate change, and a lot of hard coal production was removed beyond the European Union, and it had energy dependence related consequences we all can see on the daily basis during the we could have seen on the daily basis during the energy crisis. Well, did the European Union take a different approach when it comes to critical raw materials? Well, let's see. Let me begin that the first communication was published in 2009, and in 2011 the European Union started preparing a list of critical raw materials needed for its progress. The first list in 2011 included 14 critical raw materials. The last one, published a few months ago in 2023, included already 34 materials being viewed as critical for needs for the European progress. And let me show you the list of raw materials being viewed by the European Union as strategic. This is the last fifth list of critical raw materials published in 2023. Well, what's the European approach towards future dependency on critical raw materials different in comparison with the European approach towards its dependency on imports for the purpose of this presentation, let's say coal? Well, I think it is, and I do appreciate it. First of all, the European Union puts enough emphasis on its domestic resources, and the European Union made it very clear in an action plan on critical raw materials published in 2020 that to make better use of domestic resources, the Commission will work with member states and regions to identify mining and processing projects in the European Union that can be operational by 2025. A special focus will be on coal mining regions and other regions in transition. In other words, the European Union is aware of the fact that it should benefit from critical raw materials located within the European territory. It means, however, that the EU will have to somehow address very stringent environmental standards regarding extraction of critical raw materials within the European Union. And this is, by the way, something already happening, and you can find a lot of much more relaxed norms regarding critical raw materials in the proposal of the European Commission's regulation on extraction of critical raw materials. So this is quite remarkable. However, I would like to be focused primarily on critical raw materials not being found in the European Union, and to be focused on developing countries and their role and how they are viewed by the European Union. Well, the approach is once again different when in comparison with the European approach towards its dependency on coal, because when it comes to coal or other fossil fuels, the European Union didn't pay any significant attention to under what conditions these fossil fuels are extracted in third countries. Or I would say was paying less attention than we all would appreciate, the European Union would. And therefore, fossil fuels were extracted, especially in third countries and developing countries, with less attention to environmental standards and other non-trade concerns or objectives we have been discussing throughout the whole conference than in comparison with similar or analogic activities within the European Union. So the standards were lowered significantly. Now the European Union says, we would like to secure supply of critical raw materials not found in the Europe. However, we do not want to import any critical raw materials. We are going to set high standards. So we are, it's strange because we are lowering the standards when it comes to critical raw materials within the European Union and lowering the standards when it comes to critical raw materials located beyond the European Union. And this relates to the notion of sustainability, The European Union would like to promote responsible mining practices for critical raw materials through the EU regulatory framework and especially beyond the European Union. And this is the list of countries, because the conference is focused on developing countries. So let me mention Democratic Republic of Congo, Zambia, South Africa, Namibia, and India. These are very important, plus one may add also China. All these countries may be viewed as developing countries having unthinkable reserves of critical raw materials. And a lot of them are producers of these minerals. So regardless of whether you want or not, the European Union has to focus on these countries because without tailored policy towards these countries, the EU can never secure substantial supply of critical raw materials to the European Union. And a very few months ago, the European Commission adopted a new communication called the Secure and Sustainable Supply of Critical Raw Materials in support of the twin transition. And let me mention some quite interesting aspects. What are the new approaches taken by the European Union? The first is called CRM Club. The European Commission would like to establish a critical raw materials club, a club of like-minded countries sharing values of the European Union. And this club should ideally, according to the European Commission, include joint partnership, its partners engaged in all phases of the value chain of critical raw materials. And European Union would like to, if all these countries gathered in this CRM club would work together on promoting labor rights and socially responsible practices in critical raw materials supply chains, and they would aim at enhancing and enabling environment conducive to sustainable investments. So these are two, in my opinion, quite interesting actions of future CRM club. The second approach to be taken by the European Union mentioned in the communication is, of course, WTO. The document mentions an agreement on investment facilitation for development being currently negotiated at the WTO level, and the European Union expects that these negotiations are going to lead to some non-trade standards or objectives to be included within the agreement on investment facilitation for development. What I do find also quite interesting is that the European Union is going to address critical raw materials and the way in which they are extracted in third countries through its trade agreements. And the communication mentions several already concluded trade agreements, most recently with Mexico, the United Kingdom, New Zealand, or Chile. And according to the Commission, all these trade agreements do include special chapters on on energy and raw materials. And I would like to make you familiar with two quite interesting articles. Let's wait what's the potential, and let's say whether these very nicely framed preambulatory languages are going to be translated into real action. However, according to Article 8, called Cooperation on Energy and Raw Materials, you can see that a thematic cooperation on raw materials is expected, and contracting parties to the trade agreement are supposed to get engaged in responsible mining practices and to develop value chain responsibility, including the contribution of the raw materials value chains to the fulfillment of the UN Sustainable Development Goals. It's easy to draft these phrases. It's much more difficult to translate them into action. But this is included right now in free trade agreements negotiated by the European Union. One other example relates to assessment of environmental impact, and each party is obliged to conduct an assessment of environmental impact of any activities related to critical raw materials extraction in third countries, of course, including the European Union, but primarily in the third countries. So let's see to what extent third countries do stay with these quite ambitious obligations inserted in trade agreements. And last, one additional comment or slide relates to second generation of sustainable investment facilitation agreements. According to the European Commission, one of them is now negotiated with Angola. It's very likely that other CFAs is going to be negotiated with Nigeria. And these CFAs, the second generation of sustainable investment facilitation agreements, are supposed to include also some references to a lot of until now for us mainly soft law principles mentioned in a lot of OECD and in UN documents. However, there is the practice to include these soft law instruments within the legally binding international treaties, and therefore to make pressure on contracting parties to really stay with these for decades soft law requirements and related to corporate social responsibility and sustainability in operations. And this is the very last slide. It includes a list of measures being either adopted already or within the process of within the EU legislative process, that also, in my opinion, and according to the European Commission, may have some impact on higher standards of protection of non-trade objectives within the extraction of critical raw materials in third countries. Let me mention the Corporate Sustainability Reporting Directive. This may make, if you are extracting critical raw materials in third countries in an unsustainable way, it can make it more complicated and difficult for European companies to get loans from European banks, for instance. However, let's see to what extent these ESG metrics and reporting activities are going to be translated into pre-election once again. So we are at the very beginning of the whole transition process, let's say. Then I would like to mention conflict minerals regulation adopted by the European Union. It promotes mandatory supply chain due diligence. Due diligence requirement is very often mentioned. Special standards adopted by the European Commission that are then reported. Let's see what's the impact of them. Proposal of a regulation concerning batteries and waste batteries. There is once again an obligation to establish supply chain due diligence policies. Currently, there is a directive on corporate sustainability due diligence directive being negotiated within the European Union. It once again includes an obligation for companies regarding actual and potential harm, and potential human rights adverse impacts and environmental adverse impacts with regard to their own operations, the operations of their subsidiaries, and the value chain operations carried out by entities with whom the company has an established business relationships. So the impact may be very significant. However, in my opinion, let's see how these proposals are finally negotiated and then enforced. And last, the example of soft law norm I would like to mention is the EU principles for sustainable raw materials. However, the practice I've identified is that the EU aims to take soft law principles such as the EU principles and to implement them into trade agreements and to push its trading partners to stick with these soft law principles. So only time will tell whether this initiative is going to be successful and whether the European Union can secure both. At the first glance, I would say that this is impossible to keep relatively high standards of environmental protection and at the same time being able to secure reliable supply of critical raw materials from third countries to the European Union. Let's see. Thank you very much for your attention. You want me to upload the presentation? Sorry? Do you want me to upload your presentation? I'm gonna have to do that.
The other part is music. It's not mine, so I decided to put just slides in.
So thank you very much, Martin, for your presentation. As agreed, we will move all the questions at the end of the panel. Now I'm going to introduce the last speaker and the last paper for today and for this conference. Mara Bisi from University of Turin, Italy, will be presenting a paper on the role of Supreme National Courts for non-trade concern, the case of FOFAL. So Mara, thanks for being here with us, and I will look forward to hearing your presentation. Thank you very much.
I'll share it.
Yes.
Okay. Good afternoon, everyone. Thanks for having me here, and thanks to the organizers of this conference and also all the participants that have made this experience really unique. So yeah, so I'm here to present to you actually a paper and a presentation with a more comparative approach, since my background was such as a comparative lawyer, but I think it could be quite interesting in this sense because I've studied quite a part of Indian law, specifically environmental jurisprudence for what concerns sustainable development in India, and to tackle climate change and also different other parts of human rights. As we're going to see afterwards, the right to a healthy environment in India is also being considered to be part of the right to life. So I think that's the first thing to say. It's quite interesting. So the title was exactly the role of national courts, and specifically the role of national supreme courts on the matter of NTCs, including the problems of environment and sustainable development and climate change, as well as fundamental rights. But we're going to focus, as you're going to see by the other part of the title, on the gLAWcal case and the environmental jurisprudence in India. So as an overview of this whole presentation, I think we can see that the theme of this conference was basically strictly related to persisting imbalances in sustainable development in developing countries. And I think that this type of problem also relates to NTCs, like non-trade concerns that we're going to see afterwards in the presentation, how we can define and how we can find a structure in the judicial system. So one of the first problems we have to tackle was related to fragmentation and the complexity of law, as Mariona actually pointed out yesterday. And I think that in this presentation, I want to try to explain this type of point of view from India, that there is a possible role for national courts and specifically national supreme courts for what concerns the implementation of soft law and customary law in developing countries in order to have up-to-date provisions and also to promote a sustainable development that is actually in India entered into force thanks to the Supreme Court jurisprudence. So I think that also the role of the Supreme Courts in developing countries can help the same developing countries have a stronger role in international trade matters and negotiations. So I will bring you, as I told you before, an example from India that I think that had a very important role in getting judicial tools to work in order to get soft law and customary law really effective and to solve some kind of problems of effectiveness, implementation, and most of all, accountability for corporations. So I would start with a brief introduction of the judiciary power in general, but I think you all know about the doctrine of the separation of powers, of course, and the fact that the judiciary power is considered to be the power to administrate justice in the name of the state. So it is a function of the state. But the main thing is that it is the administration of justice between two different subjects. So in that sense, it's like a bottoms-up approach. So the role of judiciary is also to interpret the law, to apply the law, but also, and more importantly, to implement the law. That I think that is the key concept for what concerns non-trade concerns, soft law and customary law, and also general policies and general principles. We're going to see afterwards how it worked very well in the Supreme Court in India. And also, we do not have to forget that judiciary, it's also a format of the legal system. I don't know if all of you are familiar with Sacco's theory of legal formants. Sacco was a very important jurist from Turin, actually from Piedmont, but let's say Turin, just for the synthesis. And he created a specific theory for legal formants. Legal formants are the parts of a legal system that collaborate and cooperate in order to create the applicable law and the applicable discipline to every single aspect of the legal system, of the life inside a single society. So the judicial formant is one of those, and we do not have to forget that, because the judiciary power is really important to adapt and apply the law, what is stated in the legislative power and the legislative formant. What you always know, but it's not bad to repeat it, it's also the nomophylactic role of Supreme Courts. And in India also, the Supreme Court has a very strong nomophylactic role. Supreme Courts have control over what is the jurisprudence behind them and have a role to create uniformity in the process of decision making, and also the role to create some kind of certainty in the law through the way of interpretation. And in India, we do not have to forget that being a country in a common law country, a common law legal system, by way of the principle of the stare decisis, you have the respect of all the decision from the main court to the lower ones. So I think that in that sense, India could be a very good example on how the judicial power can help to understand the applicable law for what concerns non-trade concerns and general principles. So I will try to make an idea, just an introductory start with the globalization and international trade. I'm not saying anything new. I know that in these days we had very interesting presentations about fragmentation and complexity of law. So in this global world, we have a real growing complexity of the law due to the amount of new subjects, new legal tools, new legal expertise, the idea of more subjects that participate to negotiations and agreements and also treaties. So this type of complexity sometimes does not help to have a great, unique general principle idea to be applicable to the single country. The fragmentation of the law is another part, is the other phase of the complexity. So we have the problem of fragmentation. Sometimes it is really difficult to identify the applicable provisions. And also sometimes we do not have this at the same level of the resources that can be applicable to a single case. So I think that in this new globalized world, due also to the complexity of the world, not only by the amount of new subjects that are participating to the negotiation at the global level, creates a problem of effectiveness of general principles, and also a problem of the implementation of the law, because it is difficult to have a type of implementation at a global level. So I wanted to introduce a little bit about non-trade concerns, which I'm sure you're like more expert than I am about. So the idea is that I tried to find a little definition of what that can be identified is, and I found like idea of externalities of commercial and or economic operations. And this type of non-trade concerns, though, I think that do not have a very cogent system for their application in every single country, in every single member state. So in this sense, we've seen that in many volumes, fundamental rights and any type of rights that are strictly related with non-trade concerns are put on the other side of the economic growth. As was said by Simpson and Schonbaum, that I hope I'm pronouncing correctly, we have liberalization versus non-trade concerns. So in the same moment, we have the international trade, a more global world, more a world that is more open to new trade ideas and developments. And on the other hand, we have non-trade concerns which are strictly related with fundamental rights and also sustainable development, the right to a healthy environment, etc., etc. So one other issue that I think also Supreme Courts may help to tackle is the relationship between non-trade concerns and corporate accountability. The problem is that the difficulties in implementation of the principle of soft law and customary international law create a problem sometimes of the application of the same provisions inside the single legal system. And that creates sometimes phenomenon of the localization, etc., etc. And in that case, the problem of corporate accountability can be a real problem. So there is no cogent system actually that forces to take NTCs into consideration during any type of negotiations, or also in the action and their commercial activity inside the single country. So we can say that there is a very strong issue of cooperation and their accountability for the problem of non-trade concerns that is not always strictly related to trade and liberalization of trade, etc., but also the accountability for the respect of the principles of fundamental rights and general principles that are also promoted by WTO. So what I'm trying to present with this intervention is that I think that the national courts, and specifically supreme national courts, can be helpful in this situation. Why? Well, because as we have seen before, they can help give effectiveness to any kind of provisions that concerns fundamental rights and also to general principles. And we're going to see that India has a specific way, a specific tool to do that, and give the implementation to the law and general to the law and all the treaties and all the type of provisions that are applicable to the single case. And also they can give a very strong hand about compliance, so that each single corporation, for instance, knows that it has to comply. Otherwise, if you do not have the practical view, it is really not that important to have also the strong rules. On the other hand, it can also help, as we've seen before, with the accountability, to the corporate accountability, and it can give normative effect through the way of interpretation. As we have seen before, it is one of the roles of the Supreme Courts to have this kind of normative effect. And as we have seen in India, is also strictly related by the fact that they are a common law system. So, what is, I think, really more interesting about the Indian legal system is that the Supreme Court developed many important judicial tools that we're going to see in this presentation to help sustainable development and to help the warranty of fundamental rights. So one of these type of these tools is the public interest litigation. The public interest litigation provided for the possibility of a representative standing for every citizen. It's not like a class action, it's something a little bit different. It's the possibility from some other organizations, for instance, NGOs, etc., to go to trial to protect individual interests in the case of violation of fundamental rights that are part of the third part of the Constitution. This type of tool was also used in the cases of environmental issues. So if there was a violation of public health or every single health in the case of they were not respected the sustainable development rules, then can have a public interest litigation to protect the rights of the single citizens. Another tool that it was really important is the direct application of international environmental principles in court as customary international law. And I think that is really important. And I think it's peculiar since other legal systems do not apply customary international law directly in courts. In the case of India, some type of principles that we're going to see afterwards, after the gLAWcal case, applied international law principles, international general principles elaborated, for instance, in the Rio Declaration, as customary international law directly in the courts. Also, they had the creation of specialized tribunals, for instance, the National Green Tribunal, and they enacted, but after the environmental jurisprudence made its course, special legislations and provisions, such as the Water Act, Air Act, Environmental Act, and further amendments. So The first case that actually involved the Supreme Court in India was the Bhopal case, for what concerns, of course, environmental jurisprudence. And it all started in 1984. 1984, in December, there was a gas leak that created deadly chemical fumes in Bhopal, where there was the headquarters of the Union Carbide India Limited. That was one of the greatest environmental disaster in history. The victims are supposed to be, they're not really counted correctly. They're estimated in 2,500 and 8,000, because it was really impossible to gather what was the correct number at the time. But many more were injured. And to date, it's not possible to establish the exact amount, the disaster that caused. So in that moment, there was a real problem on where to begin the claims for compensation. So many victims went to the District Court of New York because the Union Carbide India was a subsidiary of the Union Carbide that had its headquarters in New York. The government also made a specific act in 1985, the Bhopal Gas Leak Disaster Processing of Claims Act, according to which the government was supposed to represent every citizen, every victim in the District Court of New York to get compensation for damages. But that was the beginning of the environmental jurisprudence in India. Why? Well, because the claim in front of the District Court of New York was rejected because of a problem of forum non-convenience. This type of exception was actually upholded by the Court of New York, and said that because of the foreign inconvenience, because the witnesses were in India and more of the victims were in India, and the gas leak disaster was actually in India, in Madhya Pradesh. So in that case, they said the District Court of New York is not competent. So what happened was they started to make the claims in front of the Madhya Pradesh High Court. So in that case, we went to the Supreme Court of India and they reached a settlement. The problem is the settlement was considered to be not really satisfactory, but in the end, it was the beginning of something. It was the beginning of more awareness. We had in 2023 a new curative petition that is, funny enough, another judicial tool that which is used in India, and it was introduced in 2002. And it was considered to be to revise all decisions in the case of gross miscarriage of justice. And I think that also this type of judicial tool is really important to implement the applicable law in India and in developing countries. I think that could be a really interesting inspiration story. So from the Bhopal case, even if it was not considered to be so satisfactory, it's supposed to be creating more awareness for what concerns environmental concerns and the type of judicial remedies that India could use in order to get sustainable development and to create a healthy environment. In fact, according to the Supreme Court, the right to a healthy environment, as we have said at the beginning, is strictly connected to Article 21 of the Constitution that protects the right to life and the right to live in a healthy environment. Then there was a further evolution in the development of this jurisprudence that I think it's really important in the creation of a sustainable solution in every single case. And apart from the direct application of international customary law, the Supreme Court in India adopted the polluter pays principle and the precautionary principle as applicable provisions. Actually, there were two principles from the Rio Declaration. Also, they applied a principle for the sustainable development, intergenerational equity, and the principle of absolute liability and public trust. I think the principle of absolute liability can actually explain the idea of corporate accountability. So the absolute liability is some way overcome the idea of strict liability that was created in England in the case Ryland versus Fletcher, that saved the corporation in the case of an act of God. In the case of absolute liability, in case of environmental disasters, in case of environmental damages, not even the act of God can help corporation get free of its liability. And also the principle of the public trust, where the state is considered to be the trustee of all the environment, of all forms of life in India. So this type of protection is also the state that in case you cannot find a cooperation on any other liable subject, you can always refer to the state. So in conclusion, I think that in this globalized world that you all expressed perfectly in your last presentation yesterday and also today, developing countries may have a role in eliminating this type of persisting imbalances in international trade and in addressing the issues of non-trade concerns. In these cases, often national courts and I may say national supreme courts better, through different ways of action. As we've seen, we have many different judicial tools, and also probably Paolo knows it better about judicial tools in China for what concerns NTCs, and have a very important role in addressing these matters, even in the cases in which the legislator actually did not provide for any of specific provisions. So national courts, and specifically Supreme Courts, have a strong impact on corporate accountability and effectiveness of soft law, customary law, and the general principles. So this is it. Thank you very much for listening. And then from here. Just to sure.
So thank you very much, Mara, for this third and last presentation. We are now moving forward to the conversation, to the panel, to the questions. I do have actually very quick comments, one comment per each. I would have more, but I will refrain to one comment for each paper. Very simple, very short. For Matjaž, for Professor Nahtigal, we heard your presentation and everything you have said about IMF. How do you see the connection between your presentation and Professor Kremer's presentation today? And so how do you connect, not today, sorry, but in any case, this presentation. So how do you connect your two presentations on your perspective, that on certain points, I would say they're similar on IMF, on other points, maybe not. So yeah, that would be the first question. Then for Martin's back, is that fair for the EU to export fossil fuel, in particular coal, abroad? I mean, not exporting, but saying resolving its problem and trying to take it from another perspective. And from the energy security perspective, of course, there is an issue there because of the collaboration, of course, of the United States, but it's not always possible. Look, for example, in the case of Ukraine.
But it's fair to import, not export.
Yeah, no, what I was saying is the climate damage is virtually exported abroad, because then it's imported and just the energy and avoided the pollution and the climate and the environmental damage in Europe. So we are bringing out, so somehow kind of externalize the issue, externalize the problem, also for political consensus, because it's easier, right? But what is the political cost? What is the energy security cost? I heard you, but is that fair? Is that fair from the EU perspective, considering that the EU is asking to developing countries in many bilateral agreements and free trade agreements, sustainable development clauses, and then on the other side, so you're pushing one side, one argument, and the other side you're throwing from the window. And then for Mara, and I will stop there, public interest litigation are really extremely important. They have been always important, and they are an angle of development. You were asking about China, public interest litigation some time ago, where the angle that was the most development in environment and in labor issues in China So would you compare what is happening in developing countries somehow on a best practice? So would you consider it? So how do you see, in a comparative law perspective, what is happening in India, since your paper was focusing in India? What are the lacking elements compared to Europe or US, or what are actually maybe the positive aspects comparatively speaking? That's it. Thank you. And then, of course, any other questions, you come here to ask. So we can make a round of questions and then collect them.
Well, thank you very much to all the speakers. It was really interesting. I would like to know, particularly, Mara, a follow-up on your presentation. Out of curiosity, I understand that the Supreme Court in India used or resorted to the polluter spray principle and the precautionary principle as customary international law, right? So they used this law, they applied this law as customary international law, you said. But my question is, how did they introduce? Because I think it's a very interesting exercise that could be exported to other courts, right? So my question is, when it comes to sustainable development and intergenerational equity, how did they argue the introduction as principles, as customary law, as interpretive tools? That's my main question. Thank you very much.
Yeah, actually, both Professor Farah and Mariona asked what I had in mind, but firstly, I would like to ask Dr. Spetz, did I pronounce it correctly, if and to what extent the European Union is considering the increasing of emissions due to the increased extraction of those essential raw materials, both in the European Union and outside. I mean, if you Google rare earth mine, you see it's a huge hole in the ground, and if we are going to increase that because we're going to need more of those materials, we will eventually end up with the earth looking like Swiss cheese eventually. So I mean, how can it be? You spoke of obligations for investment treaties and stuff concerning environmental impact assessment and sustainable mining, but what if in the big picture it looks like it isn't really sustainable? So how is the European Union considering this aspect? How, if, and to what extent? And I'm going to connect to her question, but it's going to be she asked you how are the courts arguing this implementation and direct application of customary law, and I would just object to the fact that all those principles of sustainable development are customary law, and surely they are not general principle of international law. I mean, unless in the theory of sources, in the classical conception. Thank you. I mean, could it be like evolution of international law, maybe through the practice of the courts?
Yeah, just very briefly, yeah, we are very much in alignment with each other, our line of arguments and analysis. So maybe there is a little bit of a departure on the conceptual and also operational basis. On conceptual basis, there are some changes. There are new generation of economic leaders at the top of the IMF, such as Olivier Blanchard in the past, Gita Gopinath as the current leading economist with much broader horizons understanding of the issues, challenges of the developing countries. Nevertheless, the IMF itself, I don't think that the operational level has changed so much. So the standard operational procedure is there more or less unchanged at the operational level, even though there are some intellectual impetus at the top. So this is a little bit of a change, but not enough. So what is missing is probably some elements of positive conditionalities, how to improve quality of institutions, developmental policies. So in this sense, maybe IMF interventionism is in some ways is insufficient, in some ways is over-sufficient because of cuts in social services, public goods, and so forth. So it's basically just, it's sticking with the standard model of market economy. You have to balance the budgets. You have to privatize as much as you can. You have to open to foreign direct investments in order to be competitive, lower your taxes, and all the boats will be lifted. The only trouble is that we don't have any success, for example, of economic development in the standardized model. So we need to have more institutional reimagination at all levels of the IMF, or like the current Kenyan president just mentioned, we need new institutions to create new ideas and institutional, more innovative approaches toward development.
Well, let me begin with the question of Paolo's question. No, it's not fair. And no, really, this is definitely not fair. And I made my best to present this practice as very problematic, especially when you end up at the COP conference every year and you discuss and negotiate future ambitions and target for future years. So having said that, I think it may be, and it should be, an issue in these negotiations, and it can be used as a very strong argument from developing countries in being pushed into being more ambitious. Dual standard, yes. And as regards the second question, I would say I like the question whether the mining itself can be considered as compatible with all the environmental standards. At the end of the day, the standards are set by the politicians. So it seems to me that the European Union is going to make it easier and to lower the standards for these particular purposes. What I do expect that it's going to be done in the way we have already experienced when it comes to more accelerated deployment of renewable energy sources. I like calling these trends as a climatization of law, because climate change is a huge problem, and however it's not an imminent problem. If it would be imminent emergency situation, we could, as lawyers, could imagine very easily invoking some emergency clauses in treaties and viewing the problem as a very sui generis case in which usually applied norms are not going to be applied because there are some circumstances preventing the application of regular norms. The problem of climate change, in my opinion, is that I have doubts to call it imminent threat. It's a long-term threat, and therefore we do not know how to respond to these long-term threats. It can be solved tomorrow, in 1 year, in 2 years, or within the next decade, and it's most likely to be solved gradually throughout the next century until it's solved, in my opinion. And therefore, it's going to be done the way I was talking about accelerated deployment of renewable energy sources. You may end up in very bizarre situations when you have, on the one hand, climate change related objectives, and on the other hand, environmental related objectives. And for environmentalists, I think this is the cause of major headache. For instance,
I didn't say that, but if you see as a whole, like these things, like remove the vegetation, so also increase dioxide emissions through that. It's not only a matter of environment, it's also a matter of change.
No, I completely agree with you, but you are doing it in order to prevent climate change from happening, because the European Union would say without these critical raw materials, you would not be able to develop technologies we need to go through the energy transformation. This is the concept of this is the rationale of the whole idea. And then it depends, because at the end of the day, it's the question, it's mainly political decision. And then politicians may put emphasis on other values throughout the time. So for instance, we are used to appreciate environmental standards or to secure high environmental protection in European countries. And I do remember a lot of examples when energy companies were companies with very large business activities, including a lot of fossil fuels activities. And these companies did want to start with building renewable energy sources or using renewable energy sources as a source of energy. And they have applied in many licenses to build wind farms. And they have struggled a lot, and most of these projects have never been granted, or licenses in most of these cases were not granted, because building of a wind farm would undermine the environmental protection of the site. And then now, when it's very much needed, the European Union has changed its mind, and now I'm talking about Recover EU and subsequent legislation by the EU. Now the renewable energy sources are the projects of common interest, and even if there is a conflict between environmental values or environmental impact assessment, renewable energy sources are going to get priority over other values. So we can wait until these conflicts of values are decided by courts, as Mara mentioned, or politicians may step in and may determine and make a decision what's going to be to create a hierarchy of values. And that's what's happening at this moment. And this is, in my opinion, what's going to happen in relation to raw materials and mining operations related to this. Good. Thank you very much.
Okay, so thank you for your questions. So I would like to say a few words before answering Paolo's questions. It's much more complicated, but about the application of direct application of international customary law. It is not probably customary law, but in the Indian Supreme Court, it was considered to be specifically the polluter pays principle and the precautionary principle. Those entered into the environmental jurisprudence as customary international law. So that was a way by which this type of principle got part of the directly applicable law. So even if I'm not debating if it is international customary law, but that's how the Supreme Court saw these two specific principles. Okay.
I was just wondering, since it's made, most likely it's not customary law, but the court deems it customary law, maybe it could expose India to responsibility in other fora. I mean, if these application, like an actual cause in that state.
India could catalyze evaluation and further state consideration that these principles have already achieved opinion reasons preference. So it could be
Yes.
And this is not the first and only instance. There are other instances also where some principles from international law have been imported by the Supreme Court.
Yeah.
So here we can see it is not the process, rather the purpose is to be achieved. So
Yes.
it is to be given and some justification, some ground to have to given. So wherever help is coming from, so they are taking help and giving.
Thank you for the perfect answer. So yes, basically that's the idea. And that also helps me answering Paolo's question, if I got it correctly, is that the idea of achieving the result and also to get an up-to-date provisions and applicable law. I think that what moves the Supreme Court in India and also what justified the judicial activism in many fields of the law. For instance, quite recently, I mean 5 years ago, but it was recently updated in 2023, the Indian Supreme Court actually legalized passive euthanasia, correct me if I'm wrong. So by way of judicial interpretation, So I think that was huge by stating that active euthanasia was too much. But indeed, in that case, passive euthanasia, by way of interpretation, it was to achieve a specific purpose. The lacking element or the issues may be that, isn't that too much? So probably the question is judicial activism justified in a certain sense? I think it is. I think it could be a great way to gain a sustainable development even faster and with correct applicable provision, but do not, because I'm in agreement with the Supreme Court most of the times. I also had the possibility to study the Sabari-Mala case that probably also made a great difficulties in the public, I think. And I am actually in agreement with the Supreme Court most of the times, but still it is the judiciary power and not the legislative one. So maybe that's the issue that I can see in this type of judicial activism. So I don't know if I answered the question.
I think so.
Okay.
And I think the structure is okay. In the Indian legal structure is that the Supreme Court, because it's common law, once the Supreme Court pronounces a decision, it becomes law of the land. So it doesn't really require a legislative transformation at all. In certain situations, the Supreme Court says this is now fundamental right. Now you make a law pursuant to it. In other cases, it just says stop. And
Yes.
that doesn't become law of the land. As you mentioned, that in India, technically, right to life includes right to life in a safe environment.
Yes,
So technically, safe and healthy environment is fundamental right in India. It's
exactly.
not definitely not being guaranteed by the government of India, but it exists.
It is, though.
Yes.
Yeah, that's the what I thought it was quite interesting about this specific Indian legal system.
Is there any study? Is there any study so the mining of or the sufficiency of deposits of critical raw material? For how many years it would be sufficient? For another 50 years, 100 years? Because coal started 150 years, 200 years, 300 years. And now we are saying these deposits are depleting, environmental degradation is happening, developing countries are responsible. Now we are talking about these deposits. Now they will start mining after 100 years. We again put the burden on them. Now you are causing, some kind of degradation, environmental degradation. So how is there any study?
No, I'm not aware of any study because, in my opinion, at the end, there are a lot of factors that are going to be taken into consideration, and not all now known reserves are going to be finally extracted. And there are going to be a lot of factors, mainly making from the perspective of the economy, meaningfulness of these extractive activities. And until you start doing the first range of activities, you can never know to what extent these discoveries are going to be useful, whether they're going to be continue drilling and then really start mining. So, for instance, in the Czech Republic, in northwest Czech Republic, there are no relatively huge reserves of lithium. However, until the first drilling operations are done, no one is very sure about final amount of minerals that can be extracted and under which costs. It can also easily happen that mining operations start, and in the meantime, new sites easily to be it's easier to be extracted are discovered, and then even this mining operations don't even extract all the minerals. So it is very, I think it's very difficult to tell.
But we have already started this, movement worldwide that works movement towards clean energy, becomes sufficient confidence in raw material.
If you're asking me whether or not these minerals have to be extracted, unthinkable amount, and no one really knows how to secure this unthinkable, very huge amount. So from this perspective, one may say that, especially whether the energy transaction is even possible, whether we have enough resources to secure all demand for all countries to make it happen around it. We were also thinking 40 years ago that the oil has peaked and we have discovered all oil reserves and it is going to reach for new technologies are evolved, making extractive activities more efficient and more affordable, and new technologies making possible to extract resources we didn't even think that may be extracted 20, 30 years ago. So this is huge for them.
Excellent. So if there are no further questions, I think it's a good time to wrap up this panel. So I'd like to thank the three speakers for their rich contribution and presentation, and immediately ask to Professor Matjaž Nahtigal to come here for the conclusions. Since I introduced the conference, I would like to give the floor to my colleague to conclude the conference, and also as a host of the event. Thank you very much.
So great. So I would like to thank all of you for excellent presentations, exchanges, inputs, questions, discussions that we had throughout these 2 days of very intensive, very lively, very rich presentations and discussions that we have all benefited from a lot, that will also enable our future research. I'm sure we will stay, all of us, in touch. We will seek opportunities for future cooperation, projects, publications, many other things. So definitely we stay in touch with the network that we have established. So I would like to thank also to our host institutions, Faculty of Social Sciences, for all of great support, for organizing, for enabling this conference, and also to our co-organizers, ESIL Interest Group for International Environmental Law, as well as American Society of International Law Interest Group, who will inform all of the these institutions about our work, our achievements, our future plans, so that we also inform you about these future possibilities. So I would definitely encourage you, all of you, to remain in contact with one another, with all of us, with co-organizers, with Professor Paolo, Farah, and me. We will also commit ourselves to do the same on our side. So just to conclude, from my personal note, I really enjoyed immensely meeting so many of you, learning so much from all of you, and definitely you presented like kind of a very inspiring moment before the summer break, and we are already planning, strategizing our future activities also on the basis of our highly valuable, rich contribution, thinking, analysis presented in our classroom. And also thank you, participants on Zoom. It was great to have you, also to have your inputs, engagements. Unfortunately, this time maybe you were not able to come to Ljubljana, but I'm sure that Ljubljana now is on the map, with the map, right? Also, so you know where to come, where to perform maybe future exchanges, cooperation, also in other formats, not only this one. Although I think this ESL format is a very productive one, but we can search many other also opportunities. So definitely we'll see each other either in Ljubljana or other places that you all come from the closer places, from very distant places, which we also admire, appreciate, and we really are very grateful to you that you were able to come, so that we have made this world more first smaller, more open, and more livable, more sustainable for our collective future. So we inspired also alternative future possibilities that are maybe not yet explored, but we believe, and we provided many examples, that future opportunities can be so better exploited for the benefit of humanity as such. So thank you all and wish you all the best.